I'm Alicia Tucker. I'm the Director of Education for the Society of the Cincinnati, and this is Dr. Saul Cornell. He's a professor of history at Fordham University and is one of the nation's leading scholars on American constitutional thought, especially the Second Amendment. He is formerly the director of the Ohio State University's Second Amendment Research Center at the John Glenn Institute and has been invited to speak at symposiums by both the Brady Center for the Prevention of Gun Violence and also the National Rifle Association. His work has been cited by the Supreme Court in cases related to the Second Amendment, and he's the author of a book on anti-federalism, and the basis of our discussion today will be a book called A Well Regulated Militia, The Founding Fathers and the Origins of Gun Control in America. This discussion will be available to anybody, but we are especially interested in helping teachers understand the history so that they can teach their students in their classrooms. And we will talk about the founding era understanding of the Second Amendment and how it's changed over time to today. So we're glad to have you.
Well, thank you very much.
To start off, you write in the preface that you stumbled upon the topic quite by accident. What happened?
Well, I actually started working on the Anti-Federalists, and I noticed that there was a lot of new scholarship on the Second Amendment, and they kept on talking about the Anti-Federalists. And the vision of anti-federalism that I found in all of this new scholarship, a lot of it done by gun rights activists, publishing in law reviews, didn't really ring true to me. It didn't sound like the Anti-Federalists I had just spent 10 years of my life working on, so I thought, this is interesting. I think I'm going to try and get to the bottom of this. So I started working on the topic, and interestingly enough, when you work on anti-federalism, you get invited to lots of academic conferences, but suddenly you show an interest in the Second Amendment, and the pages of the New York Times are open to you, and reporters are calling you. These days, when I pick up the phone, it could be Al Jazeera, it could be the BBC. People are very interested in guns and guns in America. It's a very hot topic.
In the preface of your book, you write how you, for this book, used resources that previous scholars on the Second Amendment didn't use. So what were some of those resources?
Well, there were two things, really. Most of the discussions of the Second Amendment, and it's really quite remarkable because there's no other part of our constitutional history or law that is so obsessed with the founding moment. I think even among those people who consider themselves originalists, people who believe we should interpret the Constitution according to its original meaning or the original intent of those who wrote it, those are two slightly different forms of originalism that are prevalent today, would admit that there's a long history, and so while you might start with the founders, you would never freeze things at the founding moment. What's really interesting is you can't have a discussion about the Second Amendment without sort of getting trapped in the founding year. It's really hard to get out of the founding year. People always go back to the founding year. They always pull quotes out from the founding year. So that, I think, is somewhat unusual in our constitutional tradition.
You also wrote that you're often amazed if people often ask you if you're pro or anti-Second Amendment, and it's like somebody asking a First Amendment scholar if they're pro-First Amendment or anti-First Amendment. Would you help us understand where you're coming from in your view of gun policy in America, where it should be now?
Well, it's interesting. I had a student who came to my office the other day and said, I see that you're teaching a class on constitutional history in the fall. And I said, yeah, are you thinking of taking it? He said, yeah, I'm really interested in the Second Amendment. I understand that that's an area of your expertise. Are you for it or against it? And I looked at him quizzically and I said, that's interesting. People ask me that all the time. If I told you that I thought that there was no right under the First Amendment to have child pornography, would that make me pro-First Amendment or anti-First Amendment? And he gave me that look that students sometimes get when you ask them a question like that, which is to say, smoke started coming out of his ears, and he had that very discombobulated look. And he said, I've never thought about it that way. I said, well, then maybe you should take my course.
So you dedicated your book to your young daughters, and you write that, I hope that when they start their families someday, the issue will no longer be so divisive in America and will no longer be plagued by the problem of gun violence. Perhaps with a better sense of the history of this issue, Americans can create the kind of society in which schools will no longer need metal detectors in their doorways. So how would a better understanding of the history of the Second Amendment make our schools safer?
Well, of course, that dedication has taken on an entirely new resonance in light of what happened in Newtown. And actually, it turns out I live quite close to Newtown. I live in Connecticut. And I think what I was astonished by in the aftermath of the horror of Newtown was in trying to get a discussion going. People had always said it's not the right time for discussion. We shouldn't have this discussion now. After Newtown, people said, okay, I guess we have to have the discussion now. But the Second Amendment kept on coming up in the oddest places, because people would suggest a kind of common sense gun regulation, like let's do universal background checks so that the only people who purchase firearms are those legally entitled. And suddenly there's all this discussion of, well, what about privacy and Second Amendment rights? And I think the great irony in all this is if you applied the kind of modern gun rights model of the Second Amendment backward to the American Revolution, we would have lost the war. Because how could you possibly have mustered a militia unless you kept track of who had weapons, unless you were able to compel them to come to muster, you fine them if they failed to maintain their weapon properly? This idea that the weapons we own need to be secretly owned by us so that we can use them against the government, which is one of the common things you hear. You even hear it coming from people in the United States Congress, of all the places that you would not expect to hear something like that come from. That is almost exactly the opposite of the vision of the founders, where they thought the well-regulated militia was there to put down insurrection, to protect the body of the people, not to destroy and undermine the government. It was not supposed to be something that destabilized republicanism. It was supposed to be something that was the apotheosis of the Republican ideal of citizens who are organized legally to act as a military deterrent and to act as a military force. People have this idea that like anyone who puts on a John Deere cap and has an AR-15 and goes off into the Michigan woods is a member of the militia. But the Founding Fathers had a different term for that. They called that an armed mob. And that's what Shays' Rebellion was. I mean, right before the Constitution, farmers in Western Massachusetts were very upset, for good reason in some sense, because Massachusetts had a very onerous taxation policy, much more onerous than many of the other new states, and they were hard hit. And they decided to close down courts to prevent farms from being seized, but they also decided to march on the courts in full military array. And this really upset people like Washington and other members of the founding generation. The only member of the founding generation that was not very upset about Shays' Rebellion was Thomas Jefferson. Of course, he's off in France drinking Chateau Latour, and he's having his slave chef Madison Hemmings make him the latest Parisian desserts. And you know, he's able to raise a glass of wine and say a little bit of rebellion then and now is a great thing. But people closer to home, at least among the people we associate with the people who gave us our Constitution, those people were deeply troubled by Shays' Rebellion.
So the correct understanding of the history of the Second Amendment would be that it's not so much the individualistic, but a civic requirement or a civic obligation to protect the society.
Yes, I mean, we tend to think of rights as very individualistic, and we tend to think of responsibilities as more collective. The 18th century was almost the opposite, where you had individual responsibility and collective rights. So for instance, if we think about the jury, you don't get to be a jury. You, as a citizen, participate in the jury with other individuals. So individuals are acting together. So it's not really a collective right, it's a right of individuals, but they're acting together with a civic purpose in mind, and they're acting together under some kind of legal authority. So that 12 people who get together and decide that you're guilty of something, that's a lynch mob. 12 people summoned to be a jury and sit in a courtroom and listen to evidence according to established legal procedures, that's a jury, and that's a protection of liberty. So the founders are very aware of people acting collectively outside of law and people acting collectively under the guise of law. And when you act collectively under the guise of law, that's a good Republican kind of behavior. And when you act collectively outside the law, that for the founders was a kind of lawless behavior that threatened republics. And republics, because they were popular governments, were the most susceptible to that kind of thing. That's the danger of Caesarism. That's the fall of the Roman Empire. That's the bread and circuses that could distract the population and lead them away from good Roman virtue, which is a concept that means a lot to the founders.
So could you help us understand why the history matters? Why should we care about what happened in the 18th century when we have issues today that threaten our safety and our peace of mind?
Sure. I think the American constitutional tradition is somewhat unique in the world in that even if you're not a strong originalist, not one of these people who believe that the Constitution's meaning is frozen in time, I think that in the American constitutional tradition, everyone even people on the left of the spectrum recognize you start with the text and you start with what the text meant at the time. Now, some people think that that's not where you end, and that's where there are disagreements. But nobody says, forget about the text of the Constitution, forget about what the founders said. Everyone recognizes that, if nothing else, there's tremendous wisdom there. And then, of course, there are different arguments about how much binding authority rests with those original ideas. Even if you're a big believer that the founders somehow bound us, there, of course, are all kinds of other ways in which the law changes. You have amendments, you have precedents, you have sometimes, without even realizing it, we imbue words and concepts with new meanings, and we think we're doing what the founders did, but we've suddenly imbued a concept with an entirely new notion. I mean, for instance, you take a recent case like Lawrence v. Texas, which is a case that establishes rights for consenting adults to engage in homosexual conduct. Anthony Kennedy, who writes that opinion, argues that's embedded in the concept of liberty. So the question is, is Anthony Kennedy's concept of liberty the same as George Washington's? I would have to say probably not. But if you're a conservative like Anthony Kennedy, I mean, he's a conservative member of the court, he still has an idea that certain concepts are not frozen in time, and liberty is one of them. So even along the left-right spectrum, there are different degrees about how... Kennedy wouldn't say we disregard what the founders said, we disregard the text of the Constitution, but he has a notion that certain of the words that they chose words with a very high level of generality. Mm-hmm. Like, I think it's very clear when they said 2 senators for every state, you'd have to be... I don't think I can even find a serious constitutional scholar or judge who would say, no, we can interpret that to be 3. I mean, there's just no way you can do that. Liberty, on the other hand, which comes to us, at least in modern law, mostly through the 14th Amendment, that's a pretty capacious word, and promote the general welfare in the preamble. Does the preamble actually provide any guidance, or is it just fluff? I mean, you could argue about that, and gives you very different visions of what the Constitution's scope is supposed to be.
The text says, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." So could you give us a sense of the period by describing what a firearm in the 18th century would be like?
Well, this is a fascinating subject because there's been a lot of historical controversy over the level of armament in 18th century America. We have a lot of good recent scholarship finally on this topic, and we can say that the founders lived in a society in which guns were obviously important. They had important functions for self-defense, for public defense, for farming, for pest control. Among the gentry, they sometimes were used to settle matters of honor. So guns are an important part of the society, but not everyone in the society has equal access to every kind of gun. For instance, pistols, the antecedents of today's handguns, were generally kind of expensive and more likely to be owned by members of the gentry, people living in urban areas where you needed maybe to, you couldn't lug around a rifle or a musket. Farmers generally wanted to have fowling pieces, which are kind of the antecedents of a shotgun. And of course, military units required muskets, which are heavier, bigger bore, and could take a bayonet. Because in 18th century fighting, once you fire that first shot, mm-hmm. by the time you've got that off, you often find that you have an army rushing at you. And so if you don't have that bayonet, if you just have a turkey gun, you're in serious trouble. So one of the things we now know is that Americans, not surprisingly, wanted guns that were useful to them, and they felt like owning these heavy military-style weapons were not most advantageous if you're an average farmer. And so actually the government had to work hard to get those kinds of weapons into the hands of the people who needed them, which would say people who would be part of the well-regulated militia. And so many states required people to own a musket, and they were forever trying to get people to live up to that obligation.
For us, we don't fear our military, but in the 18th century Americans, they did fear a professional army. Why?
Well, of course, what is truly astonishing when you try and compare their world to our world is we have the most powerful standing army in the world. They were quite afraid of a standing army, although Washington and those who fought in the American Revolution came to realize you could not defend America without a professional army. So the Americans start out with this very romantic notion of the militia because it fits with this idea of the citizen soldier, fits with this suspicion of centralized government. In the world they had grown up with before the French and Indian War, militias could pretty much handle most of the responsibilities, put down slave rebellions, deal with intermittent kinds of warfare along the frontier with Indians, but not a sustained European-style land campaign. And of course, what they find first in the French and Indian War and then later in the American Revolution is the militia has certain things that it's very good at. It's very good at these sort of hit-and-run kinds of things. It's very good at harassing people deep into enemy territory, so to speak, so that the British are constantly worried about their lines of support because there's militias throughout America. They can't just assume the area is pacified if they've secured the major towns or seaport cities. So the militia is important in the American Revolution, but Washington in particular and people like Henry Knox come to realize we must, unfortunately, have a kind of European-style army. And we now have the most powerful military force in the world. Someone told me that American military spending is probably more than the next maybe 15 or 20 industrialized nations put together. We should maybe check that fact, but there's no question we spend more on our military than any industrialized nation in the world.
So why did the people fear it?
Well, I think the people fear it because they are familiar with English history. They're familiar with King Charles raising an army and Parliament raising its own army. So the English Civil War experience is very, very well known to them. They're also worried that in 1688, that great moment where England finally asserts the supremacy of Parliament, they pass a Declaration of Rights, including a right related to arms. That, again, you had a king who was trying to raise foreign forces, trying to raise religious sectarianism and appoint officers in the army who had one particular religious faith as opposed to another. In this case, it was Catholic instead of Protestant. And so they grow up with this idea that if you have a professional military and you have a strong executive, and in England you had a monarch, that was a very dangerous combination. So they grow up with this preference ideologically for a militia over a standing army. The problem is the facts on the ground are quite different when they actually have to fight a war.
What instances happened during the Revolutionary War of disarmament, of the monarch trying to disarm the people?
Well, this is what's interesting, of course. In contemporary rhetoric, you hear a lot about, and there's no question the English tried to interdict gunpowder. Of course, they're marching on the magazine in Concord, Massachusetts. Virginia erupts when Royal Marines sneak into the magazine there and steal gunpowder. And Lord Dunmore, in response to the Virginia militias mustering, says, he'll raise Williamsburg to ashes and free the slaves, which in fact causes even more people to become enraged. That efforts of the British government to disarm Americans are very well, very much on people's minds after the American Revolution. What we forget today is that, of course, the American revolutionaries disarmed lots of people too.
What do you mean?
The American revolutionaries disarmed loyalists in New York and Pennsylvania. They disarmed rebels in places like Shays' Rebellion a little after the American Revolution. So I think it's a general rule that governments, whatever government is in power, usually is pretty comfortable disarming people they believe are threatening. And the American revolutionaries are no different. We have erased that side of it where we disarm the loyalists. We also tend to forget that we confiscated a lot of property from loyalists. It's hard to imagine an American government, although I suppose after Kilo versus New London, maybe not so hard to imagine for some people. But the idea that American government's in the business of taking away property and redistributing it, we usually associate that with different revolutionary traditions. But there was a little bit of that in our own. So I think the American Revolution is a lot more complex than most people realize. There are conservative strains of the revolution, quite radical strains of the revolution, and then what I would call the sort of central tendency of the revolution, which is built around these core Whig values. And it does generally recognize private property subject to regulation. It recognizes a right to keep and bear arms subject to regulation. It recognizes a right to speak and to publish and freedom of the press, they're not so much subject to regulation, but at least in the founding generation, subject to punishment if you step over the line. I think our modern notion of freedom of the press, which is very robust, it'd be surprising how narrow the founders' conception was. They still, many of them believed in the idea that you could libel government. They believed in seditious libel, and people got punished. Newspaper editors got published during the Alien Sedition Crisis in 1798. So the traditions that we have evolved and we live under are rooted in the ideas these people articulated. But everything that we've come to hold dear is not always really attributable to the founders. And I think they would have been okay with that, because Madison, one of the greatest of the founders, at least in terms of constitutional thought, not a very good president really, but some people are just not meant for that office. So Madison clearly believed, he uses this great metaphor of a lighthouse, that history is like a lighthouse that shines this beacon, and it's best at showing us where not to go and much less at where we should go. Because I think the founders knew what the dangers of the past were, but they were trying things that had not been tested before. This idea of a republic this size had not been tried. So there were certain leaps of faith and educated guesses they made in forming their political and constitutional systems. So they were very, very well attuned to the lessons of history, but they realized you can't move forward if all you do is emulate the past.
So let's talk about the once we won the war, and then we're creating a new constitution. And
did we win the war?
We did win the war.
Oh, good.
It's what the Society of Cincinnati is all about. So we won, and but the country was precarious under the Articles of Confederation, so we needed to create a new constitution. And when they proposed it, when the framers proposed the constitution or crafted it to be proposed for ratification, they were ambiguous about the standing army and the role of the militia in the Constitution. Could you describe about the responsibilities of the states or the federal government?
Well, under the Articles of Confederation, the bulk of authority over the militia rests with the states. And there are a lot of people who are concerned that under Article 1, Section 8, the new federal government was going to set regulations for the militia. The states could still appoint officers. And they were to train the militia according to the regulations set by the federal government. But this spooked a lot of people like Patrick Henry in Virginia, that suddenly the most important way that the states could protect themselves, could put down rebellions, whether they be slave rebellions in the South or Shays' Rebellion in the North, or defend against frontier encounters with Indians, this most important institution was no longer under their control. They had to share it with the federal government. And in particular, they were worried that they knew they had had problems arming the militia, because again, people wanted the guns that were useful for them, not the guns that the militia would find most advantageous in a military situation. Mm-hmm. And they were worried the federal government would just not get around to arming it. And today the fear of disarmament is always these black helicopters or people coming in the middle of the night to kick in your door and take your guns. The fear of disarmament in the 18th century, I mean, there is this fear during the Revolution of active disarmament by the British, but by the time the Constitution is being debated, a very different fear has emerged as the serious threat to the militias, and that's the fear that government won't do anything. And by sheer inaction, the militias will be disarmed because armaments rust, these armaments get broken, they need to be repaired. So even if there were enough muskets to go around, they would have to be kept in good repair. And so there is a sense that it would be very easy and very subtle to effectively disarm the militias by actually just doing what politicians are best at doing today, which is nothing. Inaction. So that is, I think, one of the hardest things for people to get their mind around, that the fears we have today that government is coming to do something to us, they could have a fear that government was coming not to do anything, and that was the problem.
Oh, that's so interesting. Part of the Anti-Federalist main concern was that there was no protection, no Bill of Rights to protect their rights. And in Pennsylvania, there was a group that proposed the first list of rights that they wanted included, and then that was later used by other states, and it was the dissent of the minority of Pennsylvania. Will you talk about how it related to the right to bear arms?
Sure. Pennsylvania is the first state to actually protect the right to bear arms. Virginia's Bill of Rights, which is actually precedes the Declaration of Independence by about a month, only protects the militia, doesn't protect the right to bear arms. Pennsylvania is the first state to do that. And the first state to protect the right to keep and bear arms is Massachusetts. And then they also tie it to common defense. So at the very end of the Pennsylvania Ratification Convention, some delegates from the backcountry of Pennsylvania bring forth a list of possible amendments. And we think, at least in part, they're influenced by George Mason's objections, which are circulating in manuscript. And one of the things they include is a right to bear arms. And they frame it in a very interesting and unique way, because the Pennsylvania Constitution of 1776 talks about a right of the people to bear arms in defense of themselves and the state, and also talks about the danger of standing armies. And in another part of the Constitution talks about a right to hunt. Well, in the convention, they fuse the right to hunt and the right to bear arms in defense of themselves and the state. And the question is that because they're thinking of things in very individualistic terms, or have they just, because they're in a rush and they've thrown together this list, they've cobbled together things and they haven't been very careful about it? And also, when you say bear arms in defense of themselves and the state, is that the same as saying bear arms in defense of himself and the state? Because later in the 19th century, states actually use that very individualistic language, like Connecticut does, for instance. Some people argue that bear arms in defense of themselves and the state is very individualistic. Other people argue, no, if you actually understand the history of Pennsylvania, particularly that it's not had a militia during most of the colonial period because Quakers are pacifists, and that you have both a necessity to bear arms for the state, but also for your local community against Indian attack, for instance, where the state of Pennsylvania is not being attacked, Carlisle's being attacked, or Pittsburgh's being attacked, or or just a group of families on the frontier being attacked. So there's this sense that the meaning of the Pennsylvania Constitution could be interpreted in several different ways. By 1790, they've rewritten actually their provision on arms bearing, and they've separated the attack on standing armies from the right to bear arms, which is interesting. So I think if you wanted to argue that there was the beginnings of a more individualistic conception, that 1790 Constitution is actually a better example than the 1776 Constitution. But I think there's still some disagreement even in 1790. I don't think it's really until the 19th century that you get unambiguous, strong individualistic language, like provisions like in Alabama, for instance, which say each citizen has a right to bear arms in defense of himself and the state. I don't think there's any ambiguity there. So the question is, why did the language change? In my book, what I argue is the fact that the language evolves in that individualistic direction suggests that the 18th century language was not generally understood to be as individualistic. So, my argument is that our understanding of the right to bear arms actually changes over the course of American history.
How did, in the Federalist Papers, what did Publius argue related to the militia and how it influenced our constitutional understanding?
Well, Publius, of course, is the pseudonym that Alexander Hamilton, John Jay, and James Madison adopt when they write in defense of the Constitution in New York. It has, since its publication, become the most influential text, I think, interpreting the Constitution. At the time, although it has become the most influential text in terms of how we understand the Constitution today, at the time I'm not sure that it was fully appreciated. It was a very complicated text, and we actually have some contemporary comments saying, that it's basically a text that is going to put people to sleep, as it may have done to some students, unfortunately. Although I think it's a great text. I think it's really interesting. And what they talk about several things. They talk about how the fear of the standing army that the Anti-Federalists have been harping on really ignores the fact that America still has a militia tradition, and that the militia tradition will continue to be important, and it will act as a check on the potential of federal tyranny. Now, that's worth pausing for a moment, because the idea that states could use their militias against the federal government doesn't sound like any militia I've heard of today, because the last time that we tried that, we tried it during that was tried during the Civil Rights era, and they sent in the 82nd Airborne to sort that one out. The time before that was, of course, the Civil War, and that didn't work so well for that idea either. But I think there's no question that that at the founding moment, the idea that states reserve this kind of this emergency option of mobilizing their militias against the federal government, I wouldn't say that's the right interpretation of the Constitution, but it's an eminently plausible interpretation for some people, and many people do make that argument. I don't think we actually sort that issue out until Lincoln.
Well, isn't that what the Anti-Federalists were arguing, because they focused on the states' rights during that period and then therefore would influence the right to militia or the right to bear arms and the militia in terms of their states' rights?
Yes, I think the Anti-Federalists very clearly believe that the militia is essential as the sort of final check against federal tyranny. What's more interesting is Hamilton and Madison, I think, are forced in the Federalist, where they might not have been so inclined at the beginning of ratification, to concede that yes, in some nightmare scenario, that is possible. I don't think if you'd have asked them when they left Philadelphia, I think they would have been, no, I don't think so, or hadn't really thought about that, doesn't sound right to me. But I think after being hounded and pounded on this issue, they concede that point. But they try to say that it's so apocalyptic in terms of its scenario that it's not worth taking seriously, but yes, it is there.
During Washington's presidency, he was setting a lot of precedents, and one of his main priorities was military reform, and he worked with his Secretary of Defense, Henry Knox, to propose a plan for that reform. So what did the plan look like, and how was it received?
Well, one of the things that Washington is very keen to do is to make the militia more effective, and he and Knox favor something called a select militia. That would be much more like our modern National Guard. I mean, our modern National Guard has evolved into a kind of organization where they can almost seamlessly integrate into combat theaters almost instantaneously. I mean, depending on the kinds of units they're in, it takes maybe a little more time. But the idea is that they actually can rotate in, and there's almost no problem with that. And that's the kind of ideal I think that Washington and Knox have, that not everyone is cut out for the military, and that we need actually to cull from our citizens the best and give them extra training and give them extra equipment, and that's a better use of our resources than this noble but impractical idea that everyone is a citizen soldier. I think Washington comes to believe that that part of the militia is more mythology than reality.
Well, and also he experienced the militia not performing as well as the soldiers in the Continental Army, and Knox saw that too as his artillery officer.
Yes, I think the militia has a number of early moments of where they distinguish themselves quite nobly. There are a couple of other moments in the Revolution where the militia does not do so well, and I think it's pretty clear that it's those moments where the militia falls apart that really weigh heavily on Washington and Knox's concerns about the future safety of America. They don't want that to happen again.
So also during Washington's first presidency, or during his presidency,
his first term,
was the Whiskey Rebellion, which also related to the views of the rights to revolution and insurrection. So what happened and how does it relate?
Well, I tend to think that the Whiskey Rebellion doesn't really get its due in American history, because in a way I find it to be one of the most important early turning points in American history. But because it turned out, we don't realize how close it came to falling apart then. So what you have is Hamilton has enacted a series of economic policies. One of them includes a tax on whiskey. It's very unpopular, particularly in western parts of Pennsylvania and Kentucky. The whiskey economy there is essential. Whiskey's a much higher profit margin. You boil down a lot of grain to a lot less whiskey. It's much cheaper to transport. And this tax is really resented, and eventually it boils over, and they start protesting. First they start protesting peacefully, and then the protests get more violent. Washington is really upset about this and is trying to figure out what should he do, and he gets very different advice from his cabinet. Hamilton is like, send in the troops and let's show them who's boss, and we can't tolerate this for a second. Other people are, the one thing we don't want to do is to call out the militia and not have them show up, because that would be the worst of all. Particularly, actually, Edmund Randolph says because of the South and, again, the danger of slavery. If slaves got wind that the militia was mobilized and wouldn't show up, he thought that would be very, very destabilizing for the South. And then, perhaps even more interesting, Pennsylvania is not so sure they need the government's help. Both the governor, the chief of the Pennsylvania Supreme Court, and the Attorney General of Pennsylvania all say, I think, we have it underhand and we will be able to deal with this. And Washington is not satisfied ultimately. He does entertain several possibilities, but ultimately he sends out some commissioners and says, look, we'll talk, but if you don't want to talk, I'm sending in the troops. The commissioners are not able to arrive at a brokered standing down of the rebels, and so he does send in the troop, and the rebellion collapses pretty quickly. But again, there's that moment where you're not really sure if Washington can actually make good on his threat to use the militia. And if, in fact, let's say the Pennsylvania militia had done what the Anti-Federalists had been talking about, had stood against the federal militia, well, we would be living in a very different United States of America. There's no question about it, but it doesn't happen that way. So I think it's a major turning point. It's just it happens in a way that unless you really know the history, you wouldn't appreciate how precarious things were.
When did the first arguments for the individual right to bear arms in self-defense, because you argue that during the Revolutionary period it was a civic responsibility to contribute to the militia. So when were the first arguments for an individual right to bear arms? When did they emerge?
Well, you have, first of all, under English common law, a right of self-defense, which I think is slightly different than the right to bear arms, but that goes back to English common law, the idea that a man's home is his castle and you have a right to defend it with force if necessary. Jefferson has a pretty expansive view of the right to bear arms, and in his alternative proposal for the Virginia Declaration of Rights, he talks about no free man shall be debarred the use of arms on his lands or tenements. It's not included in the Virginia Declaration of Rights, but Jefferson is thinking in those more expansive individualistic terms. So there are signs of it in the 18th century. My argument is it's not yet the dominant model. It's very clear that by the Jacksonian era, where America is more democratic, it's more egalitarian, the word individualism has come into the American language from the English translation of de Tocqueville's Democracy in America, where he talks all about individualism as a kind of new attribute of in the world, really, that America is the first individualistic society, and that's different than egoism. He coins the term individualism to describe it. So I think it makes a lot of sense historically to see all those forces converging. And it also is a time where the market revolution is making goods more readily available, and you're seeing handguns, cheap and reliable handguns, come onto the market for the first time. And that completely changes the dynamics. It's the first time you get a gun violence problem. And that's also the first time you get modern style gun control laws, because the goal no longer is sort of a well-regulated militia or a general set of regulations about gunpowder storage or about discharging firearms. They're actually trying to get certain weapons out of the market because they're so inherently dangerous. That's a distinctly modern approach. And frankly, the other thing that we now know, which we didn't know until recently, is that the era of the Second Amendment, after the American Revolution, homicide rates in many parts of America are at all-time lows. It's one of the few points in American history where homicide rates are much lower in America than in Europe, for instance, where now our homicide rate is much higher. So the market revolution and these new guns and the more atomistic society and more social unrest, slavery is heating up, immigration is becoming a problem, beginnings of industrialization. You have all these social ills. Well, you throw readily available handguns into the mix, and also unprecedented alcohol consumption.
Oh.
This is a moment in American history where Americans consume more alcohol per capita than any point in American history. All of those things contribute to a not particularly good situation in terms of public safety.
So speaking of the issue of slavery heating up, how did abolitionists influence the understanding of the right to bear arms?
Well, in antebellum America, as slavery heats up, you both have an intensification of abolitionism and a response among pro-slavery forces. Now, what's interesting is as we were talking about, you have this new problem of handgun violence and knife violence, because the Bowie knife in particular becomes a serious problem. So you get laws passed against carrying concealed weapons in both the North and the South, but interestingly, you only get cases brought to court in the South. And I now know, based on some research I've done since the book, that the two different traditions emerge. In the North, it's much more restrictive. In the South, it's much more divided. So some courts say, and this is interpreting their state arms-bearing provisions, some courts say, well, you can't do this because the right to bear arms is about an individual right and it's very expansive. Some courts say, well, the right to bear arms is an individual right, but this is okay. And then some courts say, well, it has nothing to do with individual rights. It's all about the militia, so obviously this is fine. So you get different traditions emerging among Southern slave-owning, slave-supporting judges. And no cases in the North, but also laws prohibiting carrying concealed weapons. That's the biggest development in terms of gun regulation in that period, the biggest new thing. And slowly, the abolitionists, as they become more and more targeted by anti-abolitionist violence, and this is not in the South, this is in places like Illinois and Philadelphia and parts of the North, they begin to fracture. They start out as Christian pacifists, that essentially we have to fight this with, the Bible. They eventually get to the point where they're starting to package Bibles and guns and ship them off to Kansas to settlers, and that's where we get this idea of breachers' Bibles, which are a word for rifles. So the abolitionist movement fractures, with the sort of Christian pacifists being militantly anti-firearms, anti-gun, and then an incredibly proactive. First, it's self-defense is okay, and so if somebody attacks you, your printing press, because you're printing abolitionist literature, you can defend yourself, but only if it's self-defense. Then it eventually morphs into this kind of John Brown, radical, truly radical, revolutionary, insurrectionary. John Brown has his own wild idea about what the Second Amendment means, and it basically is a right to arm slaves to overthrow slavery. Now, if you read the original Second Amendment, I guess you have to read in between the lines to see where they put that in there, but John Brown is pretty sure it's in there.
So the slaves were freed, and then in the South, black codes developed that, and part of in the codes prevented freedmen from possessing guns, and then the KKK committed acts of terror and intimidation, and then how did the issue of the militia contribute to that the circumstance?
Well, in the Reconstruction Era South, it's a very complicated situation. So the first thing we have is the old Southern militias reforming as pro-Confederate and anti-black. And that obviously is deeply troubling to Republicans. And you have the black codes, which are targeting African Americans for disarmament. They're racially targeted laws. So Republicans in the South are horrified. And again, we tend to treat a lot of these groups in American history as though they all speak with one voice, but they're usually complicated coalitions and spectrums of views. So the part of the Republican Party that was the old abolitionists who really were sending rifles to Kansas, they continue to see the Second Amendment in very individualistic terms. And they believe the disarmament of blacks is a violation of sort of an individual right of self-defense. There are other parts of the Republican coalition that are more sort of old Whig, antebellum Whigs, and who really believe in government regulation very strongly, and who are less troubled by this as a violation of individual rights, and they are more worried that they are racially motivated laws, and they quickly realize that the only way to stabilize the South and actually to protect African Americans is not some individualistic arming, but recreating militias. Militias that are loyal to the government of the United States, not to the old Confederate ideals. Now, they're Republicans, so of course they want African Americans involved in this because they're an important constituency, they're an important segment of the population. The moment they allow African Americans into those militias, white Southerners refuse, unless they are, what would pejoratively have been called carpetbaggers, which is to say people from outside the South who've moved to the South in the aftermath of Reconstruction. So now you have these Negro militias, which are absolutely essential because you have these paramilitary groups like the KKK, and they have other versions of them besides the KKK. And so you have tremendous violence in the South. And sometimes it's violence between these competing military and paramilitary groups. And in response to that, you actually have Republicans passing gun control laws in the South trying to deal with some of this violence. And you actually have the first cases that go to federal courts applying the 14th Amendment. The first time that the 14th Amendment went to federal court around an issue of the Second Amendment was when they disarmed the Negro militia in South Carolina. They took away their guns. And what's really fascinating about that, although it tends not to figure in modern debates because, again, it doesn't really fit our nice little mythic history or a nice little dichotomy, is you have the KKK, whose lawyer is, if I'm not mistaken, I think he actually was the lawyer in the Dred Scott case, who's a Democrat, who's defending the Klan against the threat of the Negro militia, arguing that the Klan was exercising their right of individual self-defense. The government's lawyer defending, or prosecuting, I should say, the Klan for taking the guns of members of the Negro militia. Fascinating. We had a recent Supreme Court case about the application of the Second Amendment through the 14th Amendment. This case was never mentioned because it didn't sort of fit our nice, gun control, gun rights dichotomy. This was, again, an example where the issues, the biggest problem with the difference between constitutional history and constitutional law, I think, having taught both and having been involved in debates in both, is constitutional law, really, the first line of any effective piece of writing is, may it please the court. And it's really about persuading judges, usually on some kind of appellate level. And the first line of any history is almost always something on the order of, things were really much more complicated than we thought. Although, obviously, we sometimes vary that to make it more interesting in terms of style. But the upshot is, historians always start with this idea that the past is much more complicated, much more ironic, there are more twists and turns, and it doesn't fit neat categories that fit our lives because they had different issues. The law, by definition, starts with our issues today. That's why something has gone to court, not because we're trying to sort out what the Second Amendment meant during Reconstruction. We want to know what it means today. So there's a fundamental tension between the way lawyers use history and the way historians write history. Now, some people would say there's no way to reconcile the two. I myself think that it is possible to do history well, stop, take a breath, and then say, what, if anything, is useful from this for the law? I think the big problem is people just say, I'm just going to go look for the history and find stuff that's useful without stopping to get the history right, pausing to say, maybe there's nothing here for me. It's really interesting, it's really important, but it just can't be made to fit into the little square pegs that we've created in our modern legal system.
So was that case the Cruikshank that you mentioned?
The case that I mentioned was actually United States versus Mitchell. Sorry, scratching my nose. The case that I mentioned was actually United States versus Mitchell. Cruikshank is the next big case that involves the Second Amendment. That one is much better known. Cruikshank results in a Supreme Court opinion. Mitchell is a little more complicated. Mitchell goes up to the federal court on a kind of complicated procedural issue, and we don't get a Second Amendment ruling. We get, I'd have to check, I'd have to actually reread the section of my book because it's not a case I teach or use very often. But Mitchell gets resolved in a way that doesn't give us a clear statement. In fact, the problem in the South Carolina KKK trial is the federal attorney is waiting for the result of this Mitchell case to know whether or not he can make a certain line of argument. And the court sort of disposes of the case on a more technical kind of grounds, and therefore he's left high and dry when he would have really liked to have had a good precedent to work with.
Well, I have in my notes that the 1910 collective reading of Cruikshank emerged and became the norm. Okay,
so for much of the 20th century, the way people argued about the Second Amendment is it an individual right or a collective right?
Which models the dichotomy today.
Which models the dichotomy of gun control versus gun rights. Although I think now actually we've even evolved in terms, I don't even think we have a gun control paradigm anymore. We've moved to this sort of gun safety paradigm, which is much more solicitous of gun owners and of the rights of law-abiding citizens to own guns, and focuses much more on restricting access by criminals and the insane and dealing with illegal gun markets. So we have, in fact, evolved even in terms of how we think about the gun regulation side of the equation. But yes, for most of the 20th century, it was either we need to get rid of a lot of these guns or we need to protect these guns. And if it's a collective right, then there's no individual right. You have no day in court. If it's an individual right, then you need to have your day in court, and it needs to be protected the way we protect any individual right. And the reason we get that language is there's a Harvard Law Review article written by a judge of the Maine Supreme Court, Lucius Emery, I think is his name. And he argues that it's basically a collective right, and it influences a generation of legal scholars. And it is pretty much how people think about it until the modern gun rights movement really begins to crank out its own version of the history from about the 70s and 80s on. And eventually that's the version of history that the Supreme Court under Justice Scalia adopts in District of Columbia v. Heller, a case from 2008.
Which is the next thing I wanted to talk about.
Isn't it amazing?
So that is a landmark case, and it was the first time that the Second Amendment was incorporated or applied, used the 14th Amendment to apply it?
Well, that's the case that comes in 2010. That's McDonald v. Chicago, which incorporates. So here's how the modern Second Amendment case law looks. The first federal court to hold that the Second Amendment protects an individual right in clear and unambiguous terms happens in a case, United States versus Emerson, which is a case from Texas. And that deals with the provision of the Violence Against Women Act, which says if you're under a domestic violence restraining order, you can't be in possession of a firearm. Why anyone would argue that if you're under a domestic violence restraining order, you should be in possession of a firearm still kind of baffles me. I suppose the argument would be, well, you still need your right of self-defense, so even if you've under a restraining order, maybe... I mean, again, it's hard for me to know that if you're dangerous enough to be under restraining order, why you should have a gun. But anyway, the argument went to court, and the court said, yes, it's an individual right, but clearly the government has an interest in protecting people, and if some administrative agency or court has decided that someone is a threat and they've issued a restraining order, then it's not unreasonable to say, you have to give up your gun. So that was decided around 2001, I think. The next case was, of course, District of Columbia v. Heller, which dealt with the District of Columbia's very, very stringent gun control law that dated from the 60s, an era of great turbulence in places like Washington. And there the Supreme Court said that the Second Amendment was an individual right, and it was an individual right tied to self-defense. And it's a case that is curious. It's a case that politicians across the spectrum have embraced and academics across the spectrum have attacked. It clearly has supporters among gun rights people and some supporters of originalism, but what's amazing is a number of very conservative jurists, J. Harvey Wilkinson and Richard Posner and Charles Freed, Harvard Law School professor, have all attacked as being judicial activism, except pro-gun rights judicial activism. And conservatives for years had been sort of against judicial activism, and the criticism now that the court had gone conservative, that they had now that their hands were in the cookie jar, it was okay to, disregard the idea of restraint, judicial restraint. So it's a 5-4 decision, but what's interesting is even the liberals argue about what the history meant. So it's an originalist decision. There are two originalist opinions, two versions of the originalist history, Scalia's version and Justice Stevens. And then there's a Breyer decision, which uses some history, but is more about prudentialism, which is, balancing social costs. So, and since that case, we've had 600 cases at the lower courts. Almost all of them have upheld the law. So it's been very good for gun lawyers. It's generated a lot of litigation. But it hasn't changed the facts on the ground because the District of Columbia's law was so much an outlier that anything that could pass the political process in America, which for the last 20 years, at least until Newtown, was fairly pro-gun rights, not fairly pro-gun regulation. Anything that could have gotten passed in the last 20 years would have been constitutionally acceptable because it wouldn't have passed otherwise. So there hasn't, the law was a great interest to academics and has produced a lot of good, interesting scholarship, but it hasn't really changed things very much. So I guess as a professor, it's good for me, but hasn't really made much of an impact. Then 2 years later, the law was applied to everywhere because the original case dealt with District of Columbia, which is this odd federal entity. Now it's applicable everywhere through the incorporation principle that you mentioned.
Well, may we understand our history and solve our problems too.
I think that history can actually show us that it's okay to regulate firearms and you won't lose your liberty, and I think that's a message a lot of people need to hear.
Well, thank you very much.
Thank you so much for having me.